appeal in the matter of James-Barclay-Watt and others, and Alpha Panareti Public Limited and others.
Mr. Parker.
May it please your lordships, may it please your ladyship. I appear on behalf of the defendants and appellants in this matter. My learned friends, Mr. Stephen Nathan, Queen's Counsel, and Mr. Nicholas Yell appear on behalf of the claimants who respond to this appeal. My Lord, before I introduce the appeal, might I just, for a moment, convey to you my personal thanks for adjourning this matter when it was due to have been heard last May.
Well, we're very glad to see you here now, and hopefully fully recovered.
I'm very glad to be here too, and yes, all well, I'm glad to say.
Can I mention a point, which is that we will need to take a short break halfway through each session. So if you find whoever's on their feet a suitable moment, about halfway through the morning and halfway through the afternoon, we'll just pause for 5 minutes.
Very well, thank you, Lord.
Yes.
My Lord, before you are 2 appeals and 1 application, and they arise out of the claimants' claims tried over 29 days in March and April of last year of misrepresentation, negligent misstatement, and negligence with regard to a development of buy-to-let properties in Cyprus. The defendants, my clients, appeal against the order of Sir Michael Burton made on the 8th of June 2021. For your lordship's note, that's in Call Bundle 1 at page 46, whereby he gave judgment against the first defendant for damages to be assessed. Reference to his judgment at paragraph 38 of that judgment reveals that he found the first defendant by its agents and literature in breach of a duty of care in failing to advise the claimants of the risks, I should say, of entering into the mortgage arrangements into which they entered. And my Lord Justice Mayles gave permission to appeal on the 31st of August last year. The claimant's cross-appeal against the order of Sir Michael Burton made on the same date, whereby he dismissed their claim against the second defendant, the managing director of the first defendant company. And reference to his judgment at paragraph 62 reveals that the judge rejected the claimant's claims that the second defendant was personally liable to them. And once more, my Lord Justice Mayles gave permission to appeal on that point alone on the 13th of December 2021. Lord, there is then, my lords, my lady, there is then a further application made by the claimants, and it's along these lines. In his judgment at paragraph 25, Sir Michael Burton concluded that the defendants were not guilty of the tort of misrepresentation in having represented to the claimants that the properties that they were buying were capable of being lawfully let to tourists under the laws of Cyprus, and that has become known in these proceedings as the lettability issue. By their notice of appeal, the claimants sought permission to appeal that finding, but my Lord refused permission to appeal that finding. The claimants now wish to contend that they are entitled to challenge the judge's findings on the lettability issue without permission by way of their respondent's notice, and my Lord has directed that that issue be resolved at this hearing. So, my Lord, with that introduction, there are 2 matters of housekeeping and 1 of order of service that I'd wish to raise with you and your colleagues. The first is this, that my own friend Mr. Nathan wrote to this court yesterday with our agreed proposal that the question as to whether or not he is entitled to run letability be determined first, so that its determination might inform the future course and timetabling of this hearing. And we're very much in your lordship's and your ladyship's hands in that regard, but that's a proposal that we make.
Well, if that's something that you both want to do, then I think we are content to follow that proposal. You run the risk, of course, that we may, having heard the argument, say that we're not yet in a position to give you a decision on whether permission is required. If we are in a position to do so, then we will, but if not, then we'll have had the argument, but you won't be very much further advanced in knowing where you stand.
No, but at least that may help us in determining how to timetable the remaining, what will be 3 days or so of this hearing in terms of how we deal with it. But I'm grateful for that indication. The other two are two small matters of housekeeping. By my Lord Justice Phillips' order of the 13th of July, he gave the parties permission to add to the paper transcripts bundle up till this morning's hearing. I have 4 pages to add to that bundle, which I have handed up, and your lordships, I hope, have a paper-clipped copy to insert into your paper bundles, if you would be so kind.
Where do you want them? At the end of tab 11?
Well, I wasn't aware that this bundle was tabbed.
What we have, the page numbers will inform your lordships as to where to put them in the bundle. It's paginated.
It seems to follow on immediately
it's tabbed
after
per day,
what
so
is
that
page 480.
yes.
Well, the first of them does, and then the second one I think is in the 6th.
Oh,
the third one is
sorry, I didn't realise they were different.
Parker, while we're doing this, I also gave the parties permission to serve an electronic bundle of a greater range of transcripts if they wish to. I haven't seen any such bundles, is that right?
Oh, I have. I assumed it would be done. I'll have it in blood.
Long, electronic ones. They will file. Your side, we're going to file them if they will.
Well, I'm informed by my learned friend that my side was supposed to be filing it, and we're checking to see.
Well, as you've added up to this morning, then presumably you're not anticipating you'll have to refer to anything else.
I doubt there'll be any reference to it. Well, there certainly won't be any reference to it this morning. And I'm sure we'll solve the problem during the course of the morning. I doubt there'll be much of any reference beyond that anyway. The second matter, my lords and my lady, is that my learned friend Mr. Nathan wanted to say something about the transcripts. Your lordships will have seen, and the ladyship will have seen in the bundles, there are transcripts of a DVD, a marketing DVD that had been circulated by my clients and on their behalf. And I think my learned friend would like you to have the opportunity to watch that DVD, not necessarily in open court, but at your own leisure if you see so fit. But I'll leave him to explain that to you.
It's very simple, my lord. In the index, your lordship will see reference to DVD covers and DVDs. Physically, it wasn't possible to put them in some way which was actually going to work simply. What I have got is a set of DVDs, but what I think will be sufficient for your lordship's purposes, if you wish to do so, is to have a DVD in relation to St. George's Hill, which very much sets the scene. The other two are very similar. We have a problem in that we were not able to find enough copies of the St. Nicholas DVD. They seem to have gone missing. We didn't have very many to start with in the first place, but it's sufficient for your lordship just to have one example to see what it looks like. If you want, I mean,
How long does it take to watch this DVD?
they're about 6-7 minutes long.
Right.
But it's something which.
All right. Well, if
you wish
you've
to
got them-
watch it at home, I mean, we have a transcript, and it really just sets the transcript in context. What I think is helpful for your lordships is to see what's on the cover, because the DVD was given with a cover, which.
All right. Well, if you've got them available, we'll have them, and if we find ourselves with nothing to do one evening, we might watch them.
Just give me a moment. Perhaps maybe have them in at the mid-morning break. And
Yes,
then
certainly.
the class can deal with it that way. Because you're obviously not going to suddenly rush out of the room and
No.
start watching.
Yes.
Well, my lord, in that event, and if your lordship and ladyship are content with our proposal, then I'll
Over to Mr. Nathan.
leave it to Mr. Nathan to make his application.
Yes.
My lord, what I need, I think, to do in this application is I bear very much in mind that out of an abundance of caution, because of the authority of Wolf, we took the view that we ought to make an application for permission to appeal. It was necessary in any event to rely upon lettability in the context of the
No,
application.
I'm afraid you can't say this was out of an abundance of causation. Look at your respondent's notice, page 18 of the bundle. You say that you believe that you
Yes.
need permission from the Court of Appeal.
Well, we did.
Is that true?
Well, we did, but my lord, what
It doesn't affect things in the end because you're either right or wrong in that belief. But
well, then, my lord, I think that my present position is that we say that we were wrong in my belief that in fact we do not need permission, and the reason why we don't need permission, we say, is that your lordships are entitled to depart from following the case of Wolf. And digital logistics on the grounds that either it was a decision which, as I hope to show you, was reached per incuriam, because one critically important matter of statutory interpretation was not looked at or regarded by the court at all in that case. Alternatively, it cannot sit well with the predecessor case, which is the case of Compagnie Noga d'importation et d'exportation against Australia and New Zealand Banking Group, which was heard by the Court of Appeal in July 2002. Now, that decision is referred to in the judgment of Sir Timothy Lloyd, but what he has done, we respectfully say, is to take from that case certain parts, but not to look at other parts which are actually highly relevant in order to arrive at his decision, which is effectively that when looking at the rules of the Supreme Court, rules of the CPR as they are now, where there are two causes of action, multiple causes of action, and the court in its order simply gives a judgment which, when you look behind the order, identifies one cause of action as being the one which results in the judgment, but not the others, that the proper construction of the statute is that those other causes of action which have been effectively dismissed must be matters which need to be appealed by the successful party, notwithstanding, as I hope to satisfy your lordships, that isn't what happens. What effectively he did by way of a statutory interpretation is to shift the category of the decision from one where the respondent is relying to support the judge's judgment upon some ground other than that which is set out in the order, and instead to say, but the court will consider that where there is where the respondent raises some other matter, and in his judgment, as we'll see in a moment, he does accept that it is some other matter, but nevertheless it is properly to be characterized as being a matter which needs to be appealed. Now, as I hope to show you when we look at the judgment in Wolf and Trinity Logistics, it's really the kind of case where the Lord Justice has, I think, taken a policy decision, but has not actually followed the principles of statutory construction, still less the principles of statutory construction, which are expressly enunciated by the court in the company Noga case. That's all put to one side. So I'm afraid, rather as quickly as I possibly can, I'm going to try to take you through what I would respectfully say are where the errors occur in the judgment of Sir Timothy Lloyd. His judgment was adopted and accepted by the two other members of the court.
I mean, you say it's per incuriam, or it doesn't sit with Noga, which may be two ways of saying the same thing.
Yes.
Do you accept that if Wolf is good law, then it knocks you out?
Yes, I necessarily must do, yes. Well, I say that. We have a subsidiary argument, which is that Wolf, there needs to be an add-on to Wolf in the case as here, where we say that in fact you've got a series of multiple claims all under the same heading of misrepresentation or misstatement, and where the part that was dismissed and the part that succeeded are so closely linked together and are part and parcel of what one might call the umbrella of misstatement, then you fall into the proper situation where you don't look at the separate counts. It's all one cause of action, in effect. And therefore you look at the umbrella of counts and see whether what is being sought to be brought forward by the respondent in his respondent's notice comes within that umbrella, as opposed to being something which is completely separate in law, which would then fall within Sir Timothy Lloyd's category of claims which need to be appealed.
I thought there was some difference there in the nature of the causes of action upon which you obtain judgment and the lettability issue.
Well, the lettability is clearly misrepresentation, simple. In relation to the misstatement in respect of the mortgage loan, it comes in, and at the moment, I think we have got, and I'll be submitting to your lordships, that the line of authority of Esso and Marden only comes in by way of a misrepresentation. It's an essential element that there has to be a representation in order to give rise to the duty of care, but they're all part and parcel. And the authorities haven't really quite separated or identified how you regard the Esso and Marden duty of care, because it obviously can't arise simply on its own in the air. It's all part and parcel of what happens in a representation claim, where the representation is not complete. You say one thing, but actually leave out something which is critically important, which amounts to the misrepresentation.
But isn't one of the important things for this purpose that the damages, at least theoretically, could be different?
Well, I don't think, my lord, the damages would be different, because in either case, it's the loss which the representee or the advisee has suffered. Yeah, but in each case, it's actually being called, what he was induced to, each of the claimants was induced to do was to enter into the contract, to acquire the investment. But at the moment, I don't see that the damages would necessarily be different. But even
I actually put it the other way around. I didn't say they would necessarily be different. Or pertinently, would they necessarily be the same?
well, well, in our case, they are the same. We make no distinction at all between what the damages are, which are entirely the same, which all flow from entering into this bad investment. The starting point, obviously, I'm sorry if I'm speaking matters which are saying things which are trite, but the jurisdiction of the Court of Appeal to hear appeals is a statutory one. It is confined to, by reference to appeals against an order or a judgment or determination. That we get from section 16.1 of the Supreme Court Act, which for some strange reason is at tab 22A of the bundle. I'm not going to take your lordships to it, but it's quite clear that what one appeals against is not the reasons given by the judge, but always one appeals against the order. It's something which is almost axiomatic. It's ingrained into barristers in their very first year of practice. And just to make that good, it's perhaps worthwhile just looking at the White Book, Volume 1, paragraph 5206. Sorry, 5206. It's page 1864. And this is really quite important, because what Sir Timothy Lloyd has done is to go behind the order and say that the court is entitled and should go behind the order in order to interpret the rules. With respect to say that's a fundamental wrong principle. At 5206, in a number of cases it's been stated that the function of an appeal court, in particular the Court of Appeal, is to deal with judgments, orders or determinations. That is to say, to deal with the result or outcome, to use non-technical terms, at the hearing in the lower court, not with findings or reasons given in the judgment. The authority given is Compagnie Noga and also Marino, Secretary of State. The law in this respect restricts winners' appeals, and it is in part based on the Senior Courts Act in 1981, section 16.1, in fact. And so on. And then an example is given where witnesses sought to challenge
Right.
judgment. Now,
Am I right that that provision isn't in the electronic version of the authorities?
No, it was added. It was added late, Lord. It's in volume. I think it's volume 2 is where I found it, and I shifted it across. But it's in the index at 22A. Under lettability. And it really should go in.
Not in mine, it isn't.
As 13A.
I haven't got it either.
You haven't got it? Ah. Well, can we,
No, the bundles arrived in this case extremely late, which I'm afraid was not very helpful. And they seem to be produced in a rather strange way, with front pages from reports and the body of the judgment taken off Bailey, or something like that.
Well, yes. What happened was that when the bundles were being put together, they were assembled by reference to transcripts, and then it was appreciated that actually what was required was the most authoritative report, as opposed to the transcript. So what was done was to put in the head note where it was followed by the transcript, or alternatively, in a large number of cases, an actual report. Right. So I do apologise for the way in which it was assembled. It's something where there was a mistake made, I'm afraid.
Okay. Anyway, I don't think we have.
None of us have it.
What does he want? Section
First of
16,
all,
is
I'll
it?
arrange for a copy to be given to your lordships at lunchtime, but we can look it up in volume 2 of the White Book. It's in tab, in section 9, and it's 9A. And your lordships will find it in. Your lordships find it at
Page 2409, I think.
24 something. 60.
Indeed.
Your lordships find it at page 2409. Subject as otherwise provided by this or any other act, and in particular the provisions in section 32A of the Administration of Justice Act 1969, excluding appeals to the Court of Appeal and so on, or as provided by any order made by the Lord Chancellor under section 56 of the Access to Justice Act, the Court of Appeal shall have jurisdiction to hear and determine appeals from any judgment or order of the High Court. And that has always been understood, and I think for certainly more than 150 years, as a reference to the order which one has in front of the court. And the importance is that you don't go behind the order at all in order to, for the purposes of what may be appealed. Obviously, when you give your grounds of appeal, you need then to go back into the judgment. Then, if we go to if we look for the moment at what is the current rule, which we find in tab 13. We go to the Respondents' Notice, which is the first item, which is Practice Direction 52C.
Sorry, are we in the
I mean, the authorities.
fund, are we?
Well, I mean, we can look it up in the White Book. But I tend to always go back to the White Book. So it's find it much easier
All right,
myself.
well, whatever you.
But, it's 52, Practice Direction 52C, paragraph 8.
Do you have a page number in the electronic bundle?
I have not got the electronic authorities one. So I'm in tab 12.
Well, some of us work on paper and some of us work electronically, so I'm afraid council does have to have
Yes, I'm
the
sorry.
ability to give both references, otherwise we are stymied.
I'll arrange for that so that I'm equipped by lunchtime.
Anyway, what is it you want us to look at?
Well, I'm looking at Practice Direction 52C, paragraph 8.
Right, page 1954.
If we look it up in the White Book, it is
1954.
yes. Now, a respondent who seeks to appeal any part of the order made by the court below must file an appeal notice. A respondent who seeks a variation of the order of the lower court must file an appeal notice and must obtain permission to appeal. And then a respondent who seeks to contend that the order of the court below should be upheld for reasons other than those given by that court must file a respondent's notice, but there's no requirement for permission. Now, your lordships need to bear in mind that in 2016, there was a wholesale change in the rules for appeals to the Court of Appeal. The original version of the CPR Part 52 was replaced, but I want to take your lordships back to what Part 52 actually said at the time, and we find that quoted helpfully in the Noga case. Which your lordships, I'm afraid, will have an 11A in the hard copy bundle.
I'm afraid I don't have it.
You don't have.
I don't have 11A.
It's actually not tabbed as an 11A.
Oh.
But if you work
I'm
backwards from
so-
12, you'll find it's the last of the cases. There is no divider between the two.
I see. Well, I'm afraid
Follows on after.
I've got a divider.
Oh, I'm
So
sorry. I found it.
I'm so
I found
I'm
it.
so sorry.
So
my
the
lord.
thing is, I've been working electronically, so I haven't actually looked at the paper bundles at all.
Yes, no,
I've now found it.
I
Thank you.
greatly appreciate it. I can't apologise too
All
much.
right, well, we're there now.
Okay, now, anyway, if we go to paragraph 7 of the judgment, the rules as they then stood in 2002, in other words, the early version of the original version. And one bears in mind that the CPR was a radical wholesale change in the procedural rules from the original rules of the Supreme Court, and that the new rules came into effect in mid, I think it's 30th of April 1999, during the course of 1999. And we have Part 52.5 read as follows. A respondent may file and serve a respondent's notice. A respondent who is seeking permission to appeal from the Supreme Court or wishes to ask the appeal court to uphold the order of the lower court for reasons different from or additional to those given by the lower court must file a respondent's notice. And then we see who is it that must actually now obtain permission. That's in the practice direction, PD 52 paragraph 7 as it then was, which provides as follows. 7.1. A respondent who wishes to ask the appeal court to vary the order of the lower court in any way must appeal, and permission will be required on the same basis as for the appellant. And that was likely to take into account almost all cases, I think, where one has different causes of action. You may well need to, if you obtain judgment on one basis, you may well need a variation of the order. You may not. In our case, we don't. Because the judge simply gave judgment for the claimants against the first defendant.
How does the judge on the assessment of damages know what damages he is supposed to be assessing?
Well, Lord, he necessarily he would, at the point of the assessment, be entitled to go behind the order itself in order to determine that. But that's at a later stage, because otherwise he's not able to determine what is the. It's at that point that one actually does look at the basis of the judgment. One always will.
I mean, there might be a road traffic injury on the face of the order.
Well, precisely. Therefore, it's inevitable that in every case where there's a decision, first on liability and then later on damages, that the judge at this damages stage will be looking at the judgment in order to see the extent to which that judgment carves his path to what it is that he has to assess. And as your Lordship says, judgment for liability could be a traffic accident, it could be anything until you actually look behind the order. And indeed, even if it had spelt out damages for a road accident, you'd still necessarily have to see whether there are qualifications, limitations, exclusions which the judge has already indicated in the course of his judgment should not be included in damages. So it's inevitable that one is going to look.
But isn't the order just shorthand? The order is shorthand for damages to be assessed for the matters found in the judgment.
Well, my Lord, at the stage of the appeal process, you need necessarily to look at the statute, because can we just look for a second at BD 52 paragraph 7, and you'll see the point I hope will emerge immediately. Respondent who wishes to ask the appeal court to vary the order, 7.1. 7.2, a respondent who wishes only to request that the appeal court upholds the judgment or order of the lower court, whether for the reasons given in the lower court or otherwise, it's very much spelled out, does not make an appeal and does not therefore require permission to appeal in accordance with Rule 52.3.1. Now, there is no room within 57.2 at that point for the approach of saying that you go behind the order in any way at all. It's simply if it's for reasons given in the lower court. So you're now looking at the reasons specifically, or otherwise doesn't make an appeal.
But if you're right, yeah. Firstly, judges should be much more careful and encouraged to spell out in their orders which cause of action they are giving damages in respect of. Because if you're right, say that there were 20 causes of action and they found in favour of the claimant on only one, you would have an automatic right to bring before this court the other 19,
well, yes,
regardless of their merit. And in fact, here you've only chosen to resurrect liability, but there are other grounds you failed on. All of them could have been resurrected.
Well, my Lord,
and that would drive a coach and horses through the whole permission process. And it seems to me that the answer to it is if you were right, then the right thing to do here would be to correct Sir Michael Burton's order to indicate the exact basis upon which he found liability, not to give you an automatic right of appeal for a ground which a member of this court has already found is not arguable.
Well, what I would say, my Lord, is a slightly different answer, which is that actually the rule, the current rule, needs itself to be changed, because it's actually it directs clearly, we respectfully say, along the lines of 7.2 that you don't need to appeal.
Well, you're reading quite a lot into a practice direction, Mr. Nathan.
Well, a practice direction which
Is no
doesn't apply to this case.
No, but what is important, my Lord, is that when you come to look at the starting point, having taken your Lordship to the White Book paragraph 5206, I would also take your Lordships to paragraph 27 of the Noga case, in which Lord Justice Waller spells out that very point, and the importance is that the winner doesn't appeal. He only needs a permission if in fact he's seeking to have a variation of the order. Then he needs permission. Can we go to the Noga case, paragraph 27? May I say at once, I readily appreciate the points that your Lordships are making, because there is something wrong. I respectfully say it's in the wording of the rule, in the sense that the rule is perfectly clear, but in terms of the policy, which, as your Lordships indicate, well, then you could be bringing forward 19 other different aspects of what went wrong below, is what I might say, from the respondent's point of view. But because you've won, you can't appeal those other 19 points. Now, the rule may itself require refinement as a matter of policy, but it isn't to be done by way of a judicial gloss. Can't do that, I respectfully say.
But it's not a matter of glossing the rule, it's a matter of interpreting the order.
Yes.
And I entirely accept what you say about looking at what the order is, but I think, as my Lord has pointed out to you, when it comes to the assessing the damages, the court doesn't say, right, there's an order for damages to be assessed for all the causes of action, which were in the claim form.
Yes.
It's not like there's default judgment for everything. You have to assess everything. The court has to interpret the order that has been made, and it interprets it by saying what the court has ordered is damages to be assessed for the cause of action that the judge found in the decision.
My lord.
And don't forget, now these days, time for appealing runs from the decision, not from the order.
Yes.
So we don't have, although we do, it is an appeal from orders, it isn't a rigid distinction between the two. And any court, including this court, can look at the order and interpret it. And what you'd interpret this order as saying is that the damages are to be assessed for the cause of action in the judgment. And that's why, if you want the judge assessing damages to assess them on a different basis than that which comes from interpreting the order, you have to appeal.
I quite accept that the judge going on to the second stage of this litigation looks behind the order, but at the court of appeal stage.
No, he doesn't look behind the order.
Well,
Forgive me. I don't think he does.
He looks at
He's
the
got no
reasons.
base. He's got no jurisdiction to look behind the order. He has to interpret the order. And if you look at cases like Sansuri, etc., what Lord Sumption said in that case is when you interpret the order, the judgment is an authoritative statement of the reasons for the order and is available for its interpretation. So you do look at the judgment, and when you look at this order made by Sir Michael Burton, you would understand that what he meant by paragraph 1 wasn't just judgment for damages to be assessed. He meant judgment for damages to be assessed for the cause of action that for which I have found proved in the judgment. And you read the two together, you don't look behind anything, you interpret the order, and you use the authoritative statement of the judge in the judgment. And that is why I would suggest you're wrong.
May I just pick that up? May I just go for a moment?
Of course.
To Lady Justice Hale, paragraph 53 in the Naga case, because she says it, I think, quite succinctly. It is clear that the statutory jurisdiction of the Court of Appeal is to hear appeals from a judgment or order of the High Court or determination of a county court. It's long been axiomatic that these words refer to the result of the hearing rather than to the reasons given by the judge for reaching that result. Judgment for the claimants. Hence, I agree with Lord Justice Waller, paragraph 27, that Lake and Lake properly understood means that if the decision when properly analysed and it were to be recorded in a formal order, would be one that the would-be appellant would not be seeking to challenge or vary, then there is no, and it's recorded in the formal order, then there is no jurisdiction to entertain an appeal. This ties in neatly with the distinction drawn in the CPR between the cross appeal, in which the respondent is seeking a different or varied result for which he needs permission, and upholding the decision on other grounds for which he does not.
Yeah.
And
As
what
I read it, that paragraph is dead against you, Mr. Nathan. Dead against you, as is paragraph 27, because Noga was all about the whole issue in Noga was whether or not the disgruntled winners had a right of appeal against certain fact findings that the judge had made in the course of his reasons. And it was held that without a declaratory order, they couldn't do so because there was no result. And the appeal is against the result of the determination on an issue. And you'll find strewn about the judgment in Noga references to issues and determination of issues. In this case, the judge has determined on various issues that you lose on some of them and you won on one. And that is the result. So when you interpret his order, if you are to suggest that you are not appealing with respect makes no sense whatsoever, because you would be challenging the findings that he has made against you on the other misrepresentations.
Well, if one is appealing against the result, which is judgment, in my client's favour, the one thing my clients are not wanting to do
No, it's not
is
though,
to
is it?
appeal against
It's
that
not
result.
judgment. It's judgment on a cause of action.
Action.
And if the order is to be interpreted, as my lord suggests, as damages for the cause of action on which the judge found in your favour in the judgment, then you are seeking a variation of that, because you're seeking that there should be an order, the effect of which is that you get damages on another cause of action as well.
Well, with respect, one looks at the words of what the order says, and to say that one is then appealing against something which is actually not in the order, it strikes me as being something. It's very odd when the rules are quite explicit, and I do want to focus for a moment on the original 52 rules, because there it's quite clear that in Rule 7, I respectfully say that had this case been coming before the court under those rules, there would be no question of having to appeal. Therefore, there must have been a shift, change in the new rule, which brings about the position that your lordships are positing.
I don't see that at all, Mr. Nathan, with respect. By all means, try to persuade us, but I don't see it would have made a slightest bit of difference whether it was brought under the old rules or the new ones.
Because if you wish to appeal, if you wish under the old rules, paragraph which are recorded in paragraph 7 in Noga, a respondent who wishes to ask the appeal court to uphold the order of the lower court for reasons different from or additional to those given by the Blakes court, then
Yes,
you
but
file a
not on
respondent's
the
notice.
basis of a different cause of action. That's not what that means.
But where you under 7.2, Rule 7, paragraph 7.2, a respondent who wishes only to request the appeal court upholds the judgment or order, whether for the reasons given in the lower court or otherwise, doesn't make an appeal. Now, one would have thought that that precisely.
No, it just comes back to the question of what does it mean by the order?
Oh,
You've
the
got to
judgment or order.
You've got to interpret the order.
All right, well, you've made your submission about that, and as you see, you're running into a certain amount of black, but we better
Yes, we will.
be quiet and let you complete your
What,
submissions on this, I think.
what is important is that if I'm right, and I appreciate your lordship may be against me, if one had under those rules the right to be able to bring forward other grounds, which would include matters in which the judge said you can't succeed, then there is a well understood principle that unless there are clear words in the subsequent statutory provision, that right should not be taken away. You actually have to look to see whether there are such clear words. And we can pick that up from first of all, can I pick up, just in response immediately to your lordship's point, go to paragraph 38 of, and it then runs straight into the point that I want to make as well, in Noga. Mr. G quite rightly says that Lord Steyne and Mr. Justice Hobhouse were dealing with a different area, and that's arbitration laws, and a different statute. But what they said has relevance to the position of a respondent seeking to defend himself. And what we are saying is we are in a defensive position. They also draw attention to how, when new procedures are brought into play, in other words, the new replacement Part 52 procedures, it is important to look critically at the question whether those new procedures have taken away rights of defence, and indeed support the view that insofar as they have not expressly done so, they ought not to be construed as having done so. Thus, there is no doubt to my mind that the position of a respondent wishing to defend his judgment by reference to grounds different from those of the judge was deliberately and for good reason maintained under the CPR. And it seems to me that as a matter of statutory interpretation, when you come to look at the new rules, I say that under the old Rule 7.2, you were entitled to bring forward anything if there were reasons or other reasons. And that was a right which was not likely to be taken away unless there were express words doing so. And when we look at the new current rule, that does not, the new rule does not substantially remove the right to bring forward other grounds. Otherwise, I would expect to say, if it had done so, what one would have needed would be a much more detailed explanation in the rules with a but after 3. But in the case of separate grounds, separate causes of action, a dismissal of such any other cause of action shall not be considered other grounds and shall be considered to come within subparagraph 1 or something of that kind. It needs further explanation, because even I think Sir Timothy Lloyd, in his judgment in the Wolf case, accepted that these were other grounds, just looking at the plain language, but he nevertheless came to the conclusion that he thought he thought that nevertheless, simply that. We can pick it up, I think, most helpfully at 84, maybe at 83. 83, I can't accept that submission. The order does not in terms record the dismissal of accusers' other claims against Mr. Wolf, but the substance is apparent from the terms of the order in paragraph 2 of the order. And in that case, the order actually spelt out judgment was given on the basis of, and we'll pick that up right from the very beginning, judgment where the deputy judge gave judgment on a particular footing. It's paragraph 30, wrongfully procuring breaches of contract. And it seems that those words must have appeared in the order. So the substance is apparent from the terms of paragraph 2 of the order. If Tuesday wished to do so, it could have appealed with permission against the dismissal of any of its other claims against Wolf, because then it was implicit that the other it failed on the other heads of claim. In practice, absent an appeal by Mr. Wolf, it would not have got permission to appeal against the dismissal of the procuring, conversion, and conspiracy claims, because there would have been no point in such an appeal. But as a matter of jurisdiction, an appeal could have been brought against those dismissals, even though not spelled out in the order, just as it could have been brought against the dismissal of the claim in deceit. As it happens, Tuesday's proposed cross-appeal against the dismissal of the procuring, conversion, and conspiracy claims would have required a variation of the terms of the order, so then you would need permission, because the order does not record the cause of action on which judgment was given quite properly. And if on appeal it were to be held that judgment should have been given on a different claim, the wording of that part of the order would need to be changed, would need to have been different. Tuesday's successful claim might have led to an order against Mr. Wolf expressed as a judgment of damages in the sum of $591,000 without recording on what causes of action the judgment was given. If in fact it was based on procuring breach of contract, on the procuring breach of contract claim, the judge having rejected the other claims, it seems to me that the position should be the same as regards challenging the rejection, even though only defensively, whether or not the cause of action successfully asserted is identified in the order. And I appreciate that's against me. Then Mr. John Knox admits that Tuesday is a respondent who seeks to contend that the order of the court below should be upheld for reasons other than those given by that court and must therefore serve in respondent's notice. It doesn't require permission. In my judgment, however, where a court has dismissed one or more of the parties' claims but has given judgment in favour on another, and that party wishes to contend that the court was wrong to dismiss the first claim, that is not a case of merely upholding the judgment on other grounds. Now, can I just pause there? It is clearly, he accepts that it is a case of seeking to uphold the judgment on other grounds, but he dismisses it as it's not merely that. And then he goes, whether or not the terms on which the order is expressed require variation, I regard the contention by a respondent that the judge was wrong to dismiss one or more distinct claims as something that requires and amounts to an appeal. And that, in that respect, uses a respondent who seeks to appeal against any part of the order made below within the terms of the practice direction. Now, the difficulty which I have conceptually about that is, as the winner, one does, the respondent doesn't actually want to appeal against the order at all. But what he does want to do is to raise another ground for saying defensively that if I'm going to lose on that head of appeal, then I'd like to succeed on this head of appeal. But that, with due respect, is actually not appealing the order.
That just takes us back round to the question of what is the order.
And therefore, the Lord, I think it's one of these points that either it appeals to your lordships or it does not. But if the word order is to be, if one is to be consistent with long authority, that is to say, is axiomatic, that one looks at the words of the order and the outcome, which is that my clients were winners and the first defendant was a loser, then one necessarily confines oneself to what is in the order, because it's very difficult to see how it is then, if one thinks about it, how it is that my clients should be appealing the order when in fact they don't want to do so, but are actually simply acting defensively. They have no wish to change any single word of that order. Judgment for liability. And therefore there's no reason why they should be, but what they are doing is saying that there is another ground and another basis upon which we are entitled to succeed in this case. I don't think that I can really take the matter further. It goes round and round. It really depends on, therefore, how your lordships choose to define the word order, and whether your lordships, I think, are then overturning what is really, would be overturning, something which has been long-standing as being part and parcel of what everyone has understood by what the word order means, rather than order and everything else that's behind it.
I think that's very conveniently done. It's probably a good time to take the break, so we will rise now and see where we go after that.
Court rise. As it's a short break, 5 minutes, the live streaming will just listen to each other.
How long will it take?
5 minutes.
Good morning.
Good morning to you.
So we will have longer.
No, I know, but I mean, yeah, I mean, because it's already Tuesday. Like, I don't know why.
Yes,
Yes, just give it one. These are all certs. So one doesn't apply to this. There's no real interest. And the other one is interest.
Oh,
How are you?
nice to meet you, dear. Yes, you look very well.
Yeah.
Right. So we just get to this.
Can you just introduce them for the judges about that they're all there?
Stephen. Sorry to interrupt. You didn't talk about your fallback, which was that the SO&R course of action was essentially the same. Quite clearly against me. But fine. No. It's quite clear. That's right. That's fine. I just wanted to check. I won't have to deal with that particular point. Well, let me think of it. I mean, it's 5 minutes because I thought your fallback. Fallback. Your fallback position was they are in fact the same. It's all wrapped up in the same thing. But then I'm going to have a dissection as to what is the cause of action.
I mean, yeah, sure. I mean, if you don't get it from them, you get it from me. But I just wanted to make
Sure.
sure.
No. Let me just check. All right. Nicholas.
Yes.
Well, I don't know. I just wanted to make sure that when he was introducing allegations, he didn't identify as fallback position, but actually it's all the same Well, I don't know. Yeah. Yeah. Well, actually, I want to do it.
Yeah.
Pretty tough ask. So you essentially. Well, that's another aspect of it.
Let me just ring him up and see what. Mind if I phone him in here?
I don't know how long the judge is going to be. They've already been a few minutes.
Good morning, everybody. I just think that these rails are going to buckle at some stage. I know. They're all queuing up. So.
Court rise.
First of all, may I just say I've been making some inquiries about the electronic version of the authorities bundle. I'm sure that there is one. I'm not sure why it hasn't got filed, because my clerk's norm is to file it at the same time as...
I've got the electronic version of the authority.
Oh.
It's just that one can't find the pages.
Because it's not paginated. Well,
It's paginated, but all I could do is guess where a page is.
You're right.
If you tell me where the page is in the bundle, I can try and find it.
Well, because unfortunately, the hard copy version, it's one of the irritations about the way these things are put together. The hard copy version isn't paginated. Therefore, we are operating on two entirely.
It doesn't matter. Don't worry, I've got the hard copies.
I'm afraid steam engine and jet engine, they're not compatible.
It's not beyond the wit of man, Mr. Nathan, to paginate a hard copy bundle.
Well, of course, Milady.
These bundles are just desperately difficult to work with.
Well, Milady, yes. If it will assist, I mean, I can certainly arrange to have the hard copy bundles that your lordship and my lady have got and have it paginated overnight. But I'm not sure that that's necessarily something that you would wish for.
I think we might want them overnight. I think we'll just have to struggle on, but here we are. All right, well, we've...
Now, may I just say, there is a fallback position in my skeleton. The umbrella argument about causes of action and the closeness of this cause of action to everything else. But on reflection, and in the light of what my Lord Justice Phillips has been saying to me, I don't think that it's something which I can press. I think that it is a matter of construction of the rule or nothing.
Yes.
So that cuts that much shorter.
Yes, well, we're grateful to you for your argument, but we have reached the clear conclusion that you do need permission to run the lettability argument, and as you have been refused permission, that's the end of the point. That means that that part of the case will fall away. We will give our reasons for that in the judgment, assuming, of course, that it arises. If you succeed in resisting the appeal, then it's all been hypothetical so far anyway.
Yes.
It seems to us that the remaining matters on the agenda can be dealt with very comfortably without needing Friday. Here we are on Tuesday. That's 2 3/4 days. We would be a bit surprised if we run into Thursday, actually, but we had very much in mind that Friday would be the day for dealing with lettability, if your lordship was permitted, hence the logic. I mean, I think there's a fair bit to say on my learned friend's appeal. In a sense, there's probably less material to have to look at in my own appeal. Well, there's maybe less material to look at, but the principles the law is more complex in the case of whether there is liability on the second defendant. So anyway, we think the case can be concluded without constraining either of you well within Thursday. So you should work, please, on that basis.
We'll work on that basis.
So I think it goes back then to Mr. Parker. Is that
Yes.
right?
My Lord, it does, yes. But before I embark on my submission, I just wanted to mention that the issue that my Lord Justice Phillips raised on the transcript bundle. I'm instructed that we lodged it into the secure document area of this court on the 21st of July, and did so again, in fact, today, just to make sure that it felt agreed. I'm afraid I don't know how that system works, but that's what
We'll chase it up over lunchtime. It might be worthwhile if somebody drops an email to the clerks just mentioning that, and they can if necessarily upload it then onto our systems.
Of course. We'll do that.
Thank you.
My Lord, the findings of Sir Michael Burton that we challenge are those that are spelled out most succinctly at paragraph 14 of his judgment. And they are these. Page 63 of Core Bundle 1. And I'm confident that it's also page 63 of the electronic version. But I'm just checking. It is, I'm grateful. Having gone through a variety of features that I'll address your lordships on and your ladyship on in one moment, he said the combination of the above features is entirely...
Sorry, which paragraph are you reading
I'm
from?
sorry, paragraph 14, page 63.
Yes.
He said the combination of the above features, and I'll take your lordships and your ladyship through those features in one moment, is entirely sufficient to persuade me that the agents and sub-agents had authority to make the representations which they then made by handing over the DVDs and the brochures and making statements as to buy-to-let and rentals and special mortgage arrangements in accordance with their training. And he also then found compelling evidence in other matters. And that is the first part of my appeal, namely the finding that the agents were, or the salesmen, I should say, were agents to advise. The features upon which the learned judge relied, I've counted as 7, arising from the preceding paragraph 13, which is the long paragraph of his judgment, and then the additional matters under the Roman numerals in paragraph 14. And the matters that he relied upon, in short, were these. Firstly, he relied upon the contractual arrangements between the parties. Secondly, he relied upon the fact and content of the DVDs and the circumstances of their provision. Third, he relied on the training seminars. Fourth, the brochures. Fifth, the website. And then sixth, the rubric that he identifies at paragraph 14.1 of his judgment, same page. Namely, please note that in dealing with whichever salesman it is, you are dealing with Alpha Panareti directly, as if from buying from Cyprus. There is no extra cost to you. And then finally, the words in the website that he picks out over the page at 64, identifying ROP UK, as I think it should be called, and ROPUC, as I've habitually called it throughout this trial, so I might slip between the two. as Alpha Panareti's exclusive partner, and the fact that ROP UK's advisors would discuss with the client the suitability of the product. The judge concluded in my submission from those 7 features that I've listed that the salesmen were engaged in a hard sell of Alpha Panareti properties in accordance with their training and in accordance with the brochures and so forth, and therefore they were more than mere canvassers and had actual authority to make the representations. That is a conclusion which is the subject of our challenge in this appeal.
Just on a point of detail, is there any significance in the square brackets around exclusive partner and in the quotation at little 2?
We'll have to look, we'll have to check the, oh I see, the significance is that the words in square brackets were added in 2009.
Oh, sorry, those are the ones he's referring to
Yes.
above. Yes, I'm sorry, I've misread that. Yeah, okay.
And of course 2009 was some 2 years or so after the last of the 8 transactions with which the trial was concerned.
Yep, no, I understand now.
And then that having come to the conclusion that the agents were duly authorised agents to advise, he then found at paragraph 34, page 73, the breach of duty, which resulted in the order that your lordships and your ladyship have been hearing about this morning. The defendants, he said at paragraph 34, plainly set out to induce and purportedly advise potential customers in their homes in accordance with the training attended also by representatives of the bank, given to agents and sub-agents, and the exclusive Alpha Panareti mortgage scheme was an integral part of the package, and he refers to evidence there from Mr. White and Mr. Williams. He continued at paragraph 37, page 75.
Incidentally, your page numbers are completely different from mine. I can work on the basis of paragraphs, but you ought to know.
Oh, well, I'm
Paragraph 37.
sorry. Well, I'll say no more about page numbers in that case. Safe. Anyway, paragraph 37. He identified the nature of the advice that was required. Came to the conclusion that at paragraph 38, 4 or 5 lines down, having considered some authority, that the defendants plainly owed a duty of care in marketing, quotes their wonderful new mortgage as a fundamental part of the offering to put these claimants on notice of the risks, which should have been obvious to them and their agents, and to include a caveat in their brochures rather than the trumpeted advantages of that special exclusive mortgage arrangement. I'll be submitting that is significantly to overstate the true effect and indeed the true nature both of the training and of the brochures and other promotional literature that was available in the case. My lords, my lady, that takes me to what I submit are the 3 essential propositions that I'll be advancing on behalf of the first defendant. My first essential proposition is that on the evidence the salesmen were in fact promoters or canvassers and not Alpha Panareti's agents to advise. Second, if contrary to that submission, there is at least a question mark over whether they had an advice-giving role, then the evidence in the case is insufficient to put them into the category of a possessor of special knowledge or skill, the Esser and Marden category, or otherwise to impose upon them some duty of care to advise, which we get from Cremasso, and I'll come back to that in a short while. But then thirdly, if contrary to each of those submissions, they did have an advice-giving role, then once more on the evidence, their failure to advise should not properly have been held to have been attributable to Alpha Panareti. So it's those three propositions which I'll seek to make good, my lords, my lady. And in doing so, I'll turn first to the first of those three, that is to say that they were promoters and canvassers and not agents to advise. My lords, my lady, I set out in my skeleton, I referred in my skeleton argument and to some authority, both from Bousted and from decided cases. And perhaps a convenient place to start is to look at the Marm case, which your lordships, ladyship will find in the transcripts bundle, which I've foolishly just closed on my in the authority bundle, I should say.
Tab 3.
I'm grateful. It's tab 3, I'm told. And it would be convenient to pick it up, my lords, my lady, at paragraph 409 of that judgment, in which Mr. Justice Picken set out a long and detailed synthesis of both what the textbook and the law stated. At that point, in the electronic bundle, that's at page 228. In fact, yes, 409. So he identified first the well-known passage in Bousted.
Are we looking at this simply because it collects together a lot of textbook and cases, or does this case stand for some proposition that you want?
It collects together what can be found, what is relevant in other cases and in the textbooks. It there are conclusions of Mr. Justice Pickens in that judgment, which I'll draw to your Lordship's attention. So it's for both purposes that I go to this case.
Okay.
So that at 409, he recites the opening passage in Bousted, identifying what an agency is. It's a fiduciary relationship which exists between two persons, etc. And then subparagraph 4. He said that Bousted also contains the proposition that a person may have the same fiduciary relationship with a principal, where he acts on behalf of that principal, but has no authority to affect the principal's relations with third parties. Because of the fiduciary relationship, such a person may also be called an agent. And an issue in the Imam case is whether and to what extent the parties alleged to be agents in that case fell within that particular category. The citations from Bousted continued at 411, and reference was made to paragraph 6035 of that text. An agent in the strict sense of the word holds a power to affect the legal relations of his principals. The power is conferred by law in the implementation of the supposed intentions of the parties, but it is not surprising the law also imposes controls on the way in which the holder of such a strong power may behave towards a person who conferred it. This is not a situation like the more usual one regulated by the law, in which the parties are in an adverse commercial relationship. Agency services are services of a special kind, even when no such power to affect legal relations was conferred, such as in the incomplete agency case of the canvassing agent. The relationship of the parties still imports an undertaking by one to act in the interest of the other rather than his own, and this likewise, though to a lesser extent, justifies the law's intervention. He then moved on to paragraph 6037, turning first to the question of how the incidence of the duties should be explained. It will be noted that the formulations of Article 1 and the present article treat the relationship of principal and agent as by definition a fiduciary one, and therefore in effect say that every agent is a fiduciary and hence owes fiduciary duties. This can be criticised on the basis that not every person who can be described by the word agent is subject to fiduciary duties. He continues, and then moving down to the next paragraph on that page, one line down, it's admitted that the fact that an agent in the strictest sense of the word has a power to alter his principal's legal position makes it appropriate and salutary to regard the fiduciary duty as a typical feature of the paradigm agency relationship. To do so will not mislead so long as two things are borne in mind. The first is that the word agent can be used in various senses, and not all persons to whom the word is applied are agents in the full or sometimes any legal sense. A canvassing or introducing agent, for instance, may do no more than to bring two parties together, and thus may in many situations do little involving the incidence of fiduciary responsibilities at all, though equally he can, as has been stated above, in some circumstances be liable for breach of such duties, as when he conceals from his principal the existence of further offers. Even canvassing agents usually have authority to make and receive communications on behalf of their principals and can be expected to act loyally in exercising those powers. A distributor or franchisee, though sometimes called an agent, is in most respects in a position commercially adverse rather than fiduciary to the person whose goods he distributes, he buys and resells. But it's inconceivable that circumstances might give him knowledge of and power over his principal's affairs, which could justify the imposition of some fiduciary duties. And then he continues, the second matter which should be borne in mind is the extent of an agent's equitable duties. He then went on to quote from the UBS case. And the UBS case, your lordships and ladyship will find in full at tab 9 of the bundle.
Okay, I don't want to slow things up. I've got it in the paper.
I'm so sorry.
I'll work from the paper copies. It's fine.
I should have made the cross reference, and I haven't. And the paragraphs to which I take your lordships and ladyship to are 90 and 91. In which the combined judgment of Lord Briggs and Lord Justice Hamblin, as he then was, starts as follows. There's an extended analysis of the legal principles relevant to the question whether a business person introducing transactions with potential link that may be regarded as a lender's agent. In Tonto Home Loans Australia Property Limited and Tavares, a decision of the New South Wales Court of Appeal, the judgment of President Olsen. After quoting in full the extract from paragraph 101 of Bousted, the judge continued. These expressions of the central characteristics of the relationship reveal the closeness of identity that is required for the relationship to exist. Not every independent contractor performing a task for or for the benefit of a party will be an agent, and so identified as it or representing it and its interests. Agency is a consensual relationship, generally if not always bearing a fiduciary character, in which by its terms A acts on behalf of and in the interests of P, and with a necessary degree of control requisite for the purpose of that role. And then picking it up again 4 lines from the foot of that page, it is sufficient to recognise that the essential characteristic is that one party A acts on the other P's behalf, and that this will generally be in circumstances of a requirement or duty not to act otherwise than in the interests of P in the performance of the consensual arrangement. And then reference is made to Bastet and other matters. And that paragraph concludes with the words, the necessary good faith implicit in the fiduciary character of the relationship reflects the character of identity or representation that the relationship essentially carries. Their lordships then continued. At 178, the judge noted that this fully accommodated Bousted's paragraph 4 so as to apply where appropriate to canvassers and those seeking to bring business to another party where the essential characters of the agency were shown to be present. Lord Falconer, acting for the Appellants, acting for the Appellants, sought to derive from the Tonto case a principle that a relationship could never be identified as one of agency if none of the main characteristics, namely authority to effect the principal's relationship to a third party's fiduciary duty or control by the principal was present. We would not be minded to go that far, but the absence of any of these main characteristics must nonetheless be a significant pointer away from the characterization of a then Mr. Lord took us to two authorities mentioned there in support of his submission that the existence of fiduciary duty was by no means an essential characteristic of agency. We agree. There are no doubt many forms of non-fiduciary agency, just as there are forms of fiduciary agency in which the agent has no authority to affect the principal's relations with third parties.
We're not concerned in this case, are we, with whether the salesman owed fiduciary duties to Alpha Panareti. The question is simply what they were authorised to say and do to prospective customers, isn't it?
To an extent, my lord, yes. I mean, what I would say is this, that there is no fiduciary relationship between Alpha Panareti and the salesman. There is an insufficient, I'll aim to seek to make this good in a moment, insufficient degree of control as between Alpha Panareti and the agents. And that it is the absence of control, the absence of a fiduciary relationship between the two are significant features which point away from the conclusion that the salesmen were agents to advise in the way found by the judge. I would add to that that if anything, it was the agents who in fact controlled the entire process, and we'll see that from the evidence in a moment. And the third feature that I rely on is the fact that the agents, their role, the starting point of their role was to bring customers to Alpha Panareti in the way of a pure canvasser, and that in fact the way in which they carried out their work was such that they weren't themselves in a position to affect Alpha Panareti's legal relations with those customers in any way. They brought them to Alpha Panareti. Alpha Panareti then carried out the work, made the decision as to whether or not the legal relations would in fact be entered into between themselves and the customers. But the agents did none of that themselves. So it's the absence in my submission of all those features which, in my submission, militate against the existence of an agency relationship between those parties, and such that they could be said, as was found by the judge, to have been duly authorised to be agents to advise. And it was the summary, returning to the authorities, and the conclusions reached by Mr. Justice Picken in the Marn case at 414 was this. He said, "It can therefore be seen that Lord Briggs and Lord Justice Hamblin had in mind three matters. First, that the main characteristics of an agency relationship include, as Lord Thornton submitted, the authority to affect a principal's relationships with third parties, and the existence of a fiduciary duty. Secondly, that the absence of such main characteristics represents quotes, a significant pointer away from the characterization of a particular relationship as one of agency. And thirdly, that the existence of fiduciary duty is by no means an essential characteristic of agency. And then he concluded at 415 and 416 in the following terms: it seems to me in the circumstances that UBS is authority for two propositions. The first is that the court should not feel constrained to find that there is an agency relationship when the facts do not support such a conclusion. Reliance on specific and limited activity might be capable of being characterized in terms of agency, but which, viewed in the round and taken together with other features which are either present or absent, do not justify a conclusion that there is an agency relationship, ought not to result in such a finding. And then 4 lines from the end. Secondly, UBS is authority for the proposition that, whilst the fact that there is no fiduciary relationship and no ability to effect legal relations are not critical to the conclusion that there is an agency relationship, they are nonetheless factors which point away from such a conclusion. He followed that by saying, it follows therefore that Mr. Saney, Queen's Counsel, was right when he submitted that a person may be an agent where he acts on behalf of a principal but has no authority to affect the principal's relations with third parties, and that it is not a sine qua non that an agent should owe his principal a fiduciary duty. It would be quite wrong, however, to approach matters on the footing that the absence of these features is immaterial, the more so when both features are absent, since to do so could result in a finding that there is an agency relationship in situations where such a finding would be wholly inappropriate. My lords, my lady, I submit that the evidence points to the absence of the relevant features that I've just taken you to, and that in the absence of those features, looked at in the round, the appropriate conclusion of the judge should have been that the salesmen were not agents to advise in the way that he found. And it's with those principles in mind that I'll take your lordships, your ladyship, to what I say are the reasons why the salesmen were not agents to advise, the first of my 3 identified earlier propositions.
I'm struggling a bit with the question why it is necessary or relevant to try and fit the salesman into some category called either agents to advise or canvassing agents. Isn't the question simply whether the judge was entitled to hold that Alpha Panareti told the salesman to go out and sell these investments on the basis that there was an advantage because it was a cheap mortgage in Swiss francs, which was a very stable currency. And they looked at it, I haven't looked at the DVD, but it looks as though that's the kind of thing that they were told to say. And why isn't, if that is right, why isn't that enough to say that the defendant is fixed with the consequence of those statements?
For this reason, or for these reasons, the first is that I say that the statements, albeit that they appeared in a relatively, I will say, limited form in the brochures and other marketing material, were no more than statements of fact. They were statements saying, if you take a mortgage through us, then you will, it will be in Swiss francs, and Swiss francs, the Swiss francs are a stable currency. So there it is. No duty to advise arose from those words. so that we're not concerned with whether or not the agents were right or wrong in such advice that they gave or didn't give in connection with the nature of the lending that was being put on offer. Their obligation was a mere Hedley-Burn duty, not to misstate the position. And there's nothing to suggest in the evidence that there was any misstatement of the bare facts of the transaction that the parties were, the clients, the customers were being invited to sign up for. So that if that is right, then the judge's conclusion that it was in breach of the duty of care to fail to give advice, in my submission, falls away, because the requirement to give advice was not part of the duty undertaken by the agents, or indeed the authority given to the agents by Alpha Panareti, who merely clothed them, or rather provided them with the information for them to impart. And you'll hear, as my submissions develop in doubtless from my learned friend in due course, if you call on it, that the agents weren't, so it would appear, given any training as to the pros and cons of the mortgage product. The agents gave no evidence to suggest that they were either asked to or did in fact give advice as to the pros and cons of the mortgage product. The agents didn't regard themselves as under a duty to do so, but merely to place the information before the customer. Say, well, this is on offer if you want it, and to describe it. And no criticism that I can see it is made of the description that they gave. Nothing they said was misleading in a Hedley-Burn sense. That was the nature of the duty undertaken, I would submit.
Okay.
My Lord, my Lady, so that I was going to identify, firstly, the first of my three lines of attack on the findings of the judge, and that is reasons why the salesmen were not themselves agents to advise. And the starting point is the language of the contracts entered into that the parties have isolated into the supplemental bundle. There being three in total, two with the company UVR, Universal Vacations Realty, I think it was called, that started the ball rolling, if I can put it that way, in September and then December 2003, soon to be replaced by ROP UK, although in fact a formal agreement with ROP UK wasn't entered into until 2007. But looking first at the language of the contracts themselves, the first one to take your lordships, your ladyship to, is the 1st of September agreement of representation between UVR and Alpha Panareti. It's at page 411 of the paper. The electronic pagination is not completely in line, unfortunately, with
not volume 1 of the supplementary bundle, it's volume 2. Yep.
Right. That's, I didn't realise it actually was. I'm so sorry.
I don't think electronic page numbering is going to work for the second bundle because it's continuous.
Yes.
Um,
And moreover, that because there have been A and B inserts as well, one can't easily do the arithmetic. At any rate, 411 of the paper bundle It's an agreement of representation made on the 1st of September 2003 between Alpha Panareti and UVR. Alpha Panareti are land developers offering property for sale. B party is agent for Alpha Panareti in Cyprus or anywhere else. So the starting point is the agent word is used. It's hereby agreed as follows. The B party will be working as an agent in favour of the A party, Alpha Panareti, for the purpose of selling property to any proposed purchaser or anywhere else, UVR will do his or her best to promote the good name of Alpha Panareti in Cyprus or anywhere else, and to undertake to organise an advertising campaign in his/her area with his own expenses. And then there's a commission rate identified there, and then an agreement that Alpha Panareti will provide UVR with all necessary promotional information free of charge, and that agreement is valid for a period of 1 year, paragraph 8. So, my lords, my lady, whilst I accept that the agent word is used in that agreement, what I would submit is that on analysis of what is actually being asked to be done, it is to promote the good name of Alpha Panareti to potential purchasers and to organise an advertising campaign.
Well, you're missing out the words for the purpose of selling property. They're agents for the purpose of selling the property. Not just promoting, but selling.
They're agents, I would submit, for the purpose for the purposes that ultimately the property is going to be sold, lady, but not necessarily. But they are not going to be doing the selling themselves, and they are not going to be doing anything, at least so far as the agreement is concerned, that by their own act can affect the legal relations.
Well, that's just peripheral. With respect, many agents don't do anything more than negotiate, and the actual contract is entered into between their principal and the third party. But it's their job to sell this property. In other words, they're there to not just promote or in effect an introduction between their principal and the potential purchaser. They're sales agents.
Well,
And it seems to me that to say that they're simply there to promote is to put a gloss on what's actually on the word of this contract.
Well, my lady, it could easily have been drafted in such a way as to make it abundantly clear that their job is to go out and sell, but it isn't. Their job is to go out and promote. Their job is to effect introductions, to bring people to Alpha Panareti. And it is because
Their job is to make people want to buy these properties.
Yes.
Yes. But that isn't the same in my submission as in selling the properties. They are promoting Alpha Panareti's product in order to attract potential buyers to come to Alpha Panareti in order to transact. And the importance is in my submission. The importance of this agreement is in the words promotion and effectively the provision of information, the source of which I accept, we can see from paragraph 6 is Alpha Panareti, but their job is the provision of information to no doubt dressed up attractively to potential purchasers to ensure that Alpha Panareti can make a sale if it sees fit.
I mean, this looks, the reading I have of this is really it seems to be like appointing an estate agent to sell the property. You'd expect them to run an advertising campaign and promote the vendor's product name and products, but this isn't like appointing a PR company or an advertising company. This is appointing them as agents for sale, like you'd appoint an estate agent. An estate agent wouldn't, at the end of the day, enter the contract on behalf of the principal, but they would market it to the public, and they would put forward the material on behalf of the principal.
But the selling client of the estate agent is also going to be expecting advice from the estate agent. He's going to be expecting advice as to how much he can sell the property for. He's going to be expecting advice from the estate agent as to what needs to be done in order to make the property more attractive than it might already be.
Well, you might or you might not. A commercial property sales company that's very experienced in marketing its property, in putting its properties to market, may very often not need an estate agent to do any of that. They will still engage an estate agent to take the properties to market.
It may very well. He might very well do that. But in that case, the agent that is taking his property to market is not an agent to advise the ultimate purchasers, and that's the distinction in my submission. That what the judge found was that these agents, these ones and Rock UK who followed them, owed an obligation to the purchasers to advise them as to the pros and cons of the package, and that isn't the postulate that my lord puts to me in my submission.
And you don't get that. You don't get that from this agreement.
No.
It doesn't say. Obviously, it doesn't say what they're going to do.
No, absolutely not. But my starting point is that, as indeed the judge's starting point was, because he recited the agreements all in quite some length in paragraph 13 of his judgment. Those are all matters that that persuaded him that these were agents to advise. And when
But an estate agent, as part of the process of selling properties on behalf of a commercial sub, was also promoting to the purchasers a finance package. I'd have thought then they would owe a duty in that regard.
that then very much, well, there's two elements of this. The first is that so far as the finance package was concerned, it was chronologically in 2003, it was at a very basic level. And we'll come on to that in one moment. But second, we need to look at the nature of the package, to use the judge's word, the wonderful mortgage that was being put in order to see whether, in fact, that kind of finding was justifiable in relation to what it was that they were actually putting out there. Because you will see, when we come to it, you will see references principally in the brochures and in one or two places in the website, which say, I would submit, no more than, we're offering a mortgage deal that we've made with Alpha Bank. this is how it works.
But that's moving on to your second proposition.
Well, it is moving on to my second proposition. But what I'm trying to do is to answer ham-fistedly your lordship's question as to whether or not the fact that the package includes a mortgage proposition means of itself that there's bound to be an obligation to give advice on it. And in my submission, it's not in my submission. It doesn't follow.
Is it a question of the salesman's duties? I mean, doesn't the judge's findings, don't the judge's findings come to this, that it's Alpha Panareti who tells the salesman to tell customers about the mortgage offer with this wonderful Swiss franc feature, and to promote that without going on to tell the salesman that you'd better at the same time tell them that there are risks. So the critical conduct is that of Alpha Panareti in telling the salesman to promote the advantages without telling them also to warn about the risks. So it all comes back to your client rather than the salesman.
Well, in my submission, no. For two reasons. Firstly, all that Alpha Panareti is in a position to do is to say, we have negotiated a deal with Alpha Bank. It's an Alpha Bank, but I mean, this again is moving into topics that I'm going to be developing.
That comes down to what the facts are. Maybe you're going to say the judge was wrong in saying that Alpha Panareti encouraged salesmen to promote this Swiss franc deal. All they really said was, well, if you want a mortgage in Swiss francs, we can do one for you, take it or leave it. But that's not what the judge found. So you may want to say the judge's findings were wrong, but if the judge's findings were open to him, then it's what your client did or failed to do that becomes relevant, isn't it?
Only to the extent that where we come to is the fact that the product is the bank's product, and the information, the detailed information provided to the salesman as to the nature of the product and anything else that they needed to know about it comes from the bank. My client is the builder. He's the builder, he's the developer. He wants to sell property. He and those that he is working in conjunction with have put together, as is quite clear, and as the judge found, a package which contains a number of various constituent elements. But the constituent elements of themselves, I would submit, are the responsibility of those who put together their individual parts. So that plainly, it's my client's obligation to ensure as best he can that the properties are, to take an example, lettable, or that they are in fact built. It's the bank's obligation within this, within the creation of the package, to ensure that the mortgage that is being promoted is accurately described and, if necessary, advised on. Although I say that the advisory question just did not come into question from the bank. It's the obligation of the agencies such as UVR in the early days or ROP UK in the later days to put together the administration, to actually send out the teams of people to ensure that the paperwork and databases and all the rest of it are kept up. It's very much a team matter where each member of the team has their own specific and important role to fulfill. It doesn't follow from that all roads should properly lead, we would say, to Alpha Panareti. And in terms of and in the context of the mortgage, we say emphatically not. In circumstances where as the evidence will show, all that Alpha Panareti did was to say, this is the nature of the mortgage deal that you'll be signing up for if you sign up with us. And there's nothing inaccurate about that. there's anything more that need any more detail or any more advice to be given on that, then it's the obligation, as we'll find out, because we'll find out about the training sessions, it's the obligation of the bank and the bank alone to impart that instruction to the various salesmen. So my lord, my lady, I do submit that the September contract at page 411 of the paper was one which, whilst no doubt the objective was that there be sales made at the end of the day, imposed upon an obligation, imposed upon the salesman, UVR, an obligation that went no further than to promote and to bring parties together. And that, in my submission, doesn't fall within the, doesn't contain the constituent elements of a true agency that I identified by reference to the authorities a short while ago. Moving to the second of the three contracts that were entered into between the parties, that's at page 425, it's the 9th of December 2003. And its essential terms are not significantly different from the September version. The difference being that the UVR company has now been promoted to being the sole agent in the UK for the purposes of selling property. But that otherwise, the essential terms remain the same. So that I submit that nothing much has changed. Nothing of significance has changed as at the 9th of December. That is to say that although the objective, no doubt, of the arrangement between Alpha Panareti and UVR is ultimately that properties get sold. Nevertheless, what UVR are being asked to do is once more to promote Alpha Panareti's good name, and once more to organise an advertising campaign, I would submit, in order to bring potential purchasers to Alpha Panareti's door. There are more detailed provisions as to commission and so forth in that agreement, but its essential nature in my submission is no different from that which preceded it, upon which I've addressed you. The third of the agreements relied upon is to be found sorry, it's 554. I can't read my writing. 554 of the paper bundle is the General Service Agreement. This time with ROP UK. ROP UK have actually been, as we'll see, have actually been on the scene pretty much from about 2005, 2006, if not even earlier than that. But the formal agreement with them is entered into on the 16th of July 2007. And the recital at 2.2 there, in my submission, reflects that which I've also been submitting in relation to UVR in reality. The developer wishes to appoint the company to assist in making introductions of potential clients for the purchase of units. And so that it isn't go out and sell these things. It's an agreement which says, bring your people to me. And there are other features of this agreement. The business at 3.1 shall mean the promotion and introduction of potential clients by the company to the developer, so that follows on from 2.2. The development is defined, other definitions there that I don't need to take you to. 3.7, marketing material, which will mean those items set out at clause 5.12. And at 5.12, it's Alpha Panareti's obligations to support ROP UK in its efforts to promote the sale of units and provide introduction to the developer, and at the expense of the developer to provide clear and up-to-date marketing materials. So, yes, of course, my clients are obligating themselves to provide the information for the salesman to take to the people to whom the potential introductions are to be made. And in a sense, one wouldn't expect otherwise. But it doesn't change the nature, in my submission, of the relationship between the two, which is that they're being sent out to purpose. They're being sent out to present facts to clients, and for those clients then to be invited to do a deal with Alpha Panareti or not, depending on their decision. It doesn't make
the company's obligation is to utilise the marketing material.
Yes.
That's 6.13, in endeavouring to attain interest. The marketing material, as I understand it, included inviting the purchaser to consider taking out an Alpha Panareti housing loan.
Yes.
Which Alpha Panareti was saying through these persons using the marketing material, that it's a package arranged exclusively for our customers. That's yes. Alpha Panareti.
Yes. It is indeed. It is part of the package that Alpha Panareti have acquired the right to a product of the banks, and the marketing material, as we'll see shortly, says this is the product. We're calling it the Alpha Panareti mortgage. All that means is the mortgage you get if you decide to buy an Alpha Panareti property.
But isn't this expressly not only authorising them, but requiring them to press clients to be interested in the product by, in particular, referring them to the availability of this Alpha Panareti loan, which further encourages that using the popular Swiss franc denomination in a low inflation economy and a haven for foreign currency. So I'm not sure why this isn't an express authorization to these agents to put forward this loan to the customers as a way of financing these transactions.
Well, in the first instance, I would say that all it is the provision of information to the salesman, saying this is what the customer will be signing up for if they decide to go ahead.
But that's not the wording. The wording is to utilise the material in endeavouring to obtain interest. So it's not just a matter of handing it over and saying, there you go. They are to use this material proactively to obtain interest.
Well, I would submit that's not necessarily the only, or indeed the right reading of it. to utilise
So
the
what is the
material.
what is the reading of it?
Well, the reading of it is hand it over.
Well, no, it doesn't
No,
say.
it says use it. As my lord points out, utilise. Utilise is more than handing it over. You're making some use of it yourself.
In endeavouring to obtain interest. It's a proactive. It's a proactive process, not merely a passive one, isn't it?
It's a proactive process, but only to this extent. The starting point of the obligation is to make introductions of potential clients. And the way to make an introduction of a potential client is to show the potential client what it is that the potential client might find him or herself interested in. And in order to show them that, then there is marketing material which is utilised.
This is unreal. This is unreal. These are salesmen who are being told they'll get 8% commission on the purchase price. They're being told to go out and tell customers that there is an uncompetitive Freudian slip mortgage arranged exclusively for Alpha Panareti clients with only 2.5% interest rate. I mean, that's the kind of thing which your client clearly wanted and authorised the salesman to say to prospective customers. I mean, what's wrong with that analysis?
There's nothing wrong with that analysis, except where it takes one. And in my submission, where it takes one is not to an obligation to give advice on the pros and cons of the contents of the package that the agents are putting forward to the customers.
But the trouble with that, again, injecting an air of reality into this commercial transaction, is that if the agents are utilising the promotional material as a means of persuading or enticing the buyers to come in, they are necessarily portraying it as a good deal. It's a good thing. It's something that it's not just as a matter of fact. This is how it works, but you've got that as an extra bolt on and an enticement. And once they're portraying it as a good thing, they are necessarily undertaking a degree of advice, like it or not. It's not simply, and there's also available this mortgage, and you can make up your own mind, perhaps, as to whether or not it's good, and scroll down to your independent financial advisor to see whether it's better than what you can get on the high street.
Milady, I would say that notwithstanding that plainly in any form of sales process there needs to be some element of persuasion. I'm not so unrealistic as to consider otherwise. That of itself, and as we'll see from the nature of the material upon which that persuasion was sought to be used, that of itself doesn't bring upon the persuader an obligation to advise as to the pros and cons of the package, but merely an obligation not to mislead or to misstate its contents. And that's the difference.
But that's going on to ground.
Oh, it is. I appreciate it.
Yeah.
Yes.
Just looking at this first stage, I mean, just to complete the effect of this agreement, the definition of the business is the promotion and introduction of potential clients by the company to the developer. And then clause 6.1.10, the company's obligation is to use its best endeavours to carry on the business and to achieve the maximum possible sale of units. And that follows on, as we've looked at already, for the using the marketing material and endeavouring to obtain interest. So it could not be clearer, could it, that the role of these persons, whether described as agents or not, was to use the material they had, including the Alpha Panareti housing loan, to get people to sign up.
Well, so far as carrying on the business is concerned, the first part of 6.1.10, we remind ourselves that the business means the promotion and introduction
But it goes on to say to achieve the maximum possible sale.
And that, in my submission, means no more than to bring as many of these people that you can to Alpha Panareti, so that
It doesn't mean just that. It means to bring them to Alpha Panareti wanting to buy. It's not merely a process of a pure introduction. It is an introduction and persuasion.
well, my Lord, I've made
Endeavour to obtain interest and to achieve the maximum possible sale.
Yes, an endeavour. I fear
It's there in black and white.
I'm going to be repeating myself if I say that so I'll simply say this, that the obtaining of interest will undoubtedly, as I said to my Lady Justice Andrews, involve an element of persuasion, but the objective of the essential duty that the agreements impose on the agents, the salesmen, is to affect the introductions. Plainly, the more persuasive they are, the more introductions there'll be. But I don't read it or put it any higher than that. So that I continue to make the submission, and the submission that started this discourse off was that the language of the contracts themselves, itself, I should say, does not render the salesman agents to advise. They may very well be, and we'll come on to this, and I won't flog a dead horse, they may very well be agents to provide information in a persuasive way. But that doesn't render them agents to advise and to impose upon them the obligation that the judge found that they had and that they breached. But
Sorry to keep bringing you back to this, but just so I understand, that there is the second of your propositions. Are we moving on to that? Or?
The first of my propositions is that they were promoters or canvassers and not agents to advise.
Right.
The second of my propositions was that if, in reality, and if you like, following the line that's been put to me both by my Lady Justice Andrews and my Lord Justice Mount, there's bound to have been some requirement to persuade, and that has some advisory element to it. Then I say that my second proposition is that the evidence is not sufficient to put them into the category of a possessor of special knowledge or skill, such as is required to get home under Essay Martin or the Cremasso case, but merely that there's a heavily burden duty not to misstate. And then, as I said,
The way you put proposition 1 is that they weren't agents to advise, and proposition 2 is, well, if they might be, they're not.
If it is to be thought that there is any element of an advisory element to the obligations that they undertook, that is still not enough to put them in the essay category.
Right. So 1 and 2 really go together.
Yes.
Well, 1 and 2 have moved together in the light of.
Well, they're basically facets of the same point, aren't really. You're saying by whichever pathway you don't get an S or a duty.
I do say that, yes. I do say that. But I do, nevertheless, I don't want to let go completely of the propositions, the following proposition, I should say, that the essential characteristics of the agency relationship that I addressed in the light of the authorities are difficult to find on the evidence, so that, for instance, and taking these in stages, it's quite clear that the salesmen were not Alpha Panareti's fiduciaries. If anyone, they were the fiduciaries of the purchasing clients. And we know that for two reasons. The first is that, for three reasons. The first is that the contracts identify that the idea, at least in part, is for the agents to bring clientele to Alpha Panareti.
This is clientele with whom the agents or salesmen, whatever we call them, already had an existing relationship.
Many of them. I can't say all of them, but many of them. And you'll see, for instance, references to that in the transcripts of the cross-examination of many, although not all, of the 8 claimants who gave evidence. So that if my lords, my lady, have the transcript bundle, paper bundle by hand, which contains the extracts parties wanted to rely on. And there are 1, 2, 3, 4, 5, 6 that I want to refer to. The first one is at page 43, which I think is the first page of that bundle. And we're looking at page 168 within that, lines 8 to 13. This is Mr. Williams. We got to the end of our mortgage term. We remortgaged through Jonathan. Jonathan is Jonathan Heath. Heath was one of the agents who was called as a witness on behalf of the claimant through Jonathan's company, so he could have given advice on what mortgage offers were available in the market at that time. We would have chosen following Jonathan's advice. Why did you remortgage? The same reason I think a lot of people do. And then moving on from there. So he was, Mr. Williams was looking to Heath for advice, which of course, to pick up on what my Lord Justice Phillips has been putting to me, isn't quite what the purchaser from an estate agent might be doing, whether residential or commercial.
That cuts both ways, though, doesn't it? Because Alpha Panareti utilised salesmen who they knew would have special clout with purchasers.
That's impossible to say. That wasn't quite how Mr. Ioannou put it when he was asked that question in cross-examination himself. In fact, if since we have this bundle open, if your lordship and
well, if we're going to be looking at a number of references to cross-examination, I wonder whether we should do that at 2 o'clock.
maybe.
Can I also ask you, as you answer after lunch, I'm not sure how the evidence came out as to whether or not the clients, customers, understood that commission was being paid to these agents by Alpha Panareti.
Well, there's something for you to think about.
Yes, indeed. All right.